Judgment in the appeal to Sustainable Shetland and the Scottish Ministers and another.
Lord Carnworth will explain the judgment of the court.
This appeal is about a proposed wind farm in the Shetland Islands and its possible effects on the whimbrel, a migratory wading bird which is protected under the European Birds Directive. The whimbrel population of the Shetland Islands is very important in national terms. At 290 pairs, it represents about 95% of the total UK population. The appellants allege that the Scottish ministers failed to have proper regard to the directive when granting consent for this project under the Electricity Act 1989. Article 2 of the directive, which applies to all species of wild bird, imposes a general requirement to maintain populations at levels which correspond to, quote, ecological, scientific and cultural requirements while taking account of economic and recreational requirements. Article 4.2 requires more specific conservation measures, including designation of special protection areas, or SPAs, in respect of protected migratory birds such as the whimbrel. In the Shetlands, the Fetlar Special Protection Area, not directly affected by this proposal, has been designated under Article 4.2. At an early stage of the proposal, Scottish National Heritage raised objections relating to potential impact on the whimbrel, relying on the directive, but not suggesting any need for special measures under Article 4.2. In response, as part of its environmental statement, the developer submitted a detailed study of the whimbrel and proposed a habitat management plan to improve whimbrel breeding success, for example by control of the main nest predator, the hooded crow. In their decision letter dated 4th April 2012, the ministers stated that they had had regard to their obligations under EU environmental legislation, and they dealt in detail with the objections relating to the whimbrel. They regarded the estimate of less than 4 deaths per year as a result of the development as, quotes, very small, in the context of up to 100 annual deaths from other causes. They also considered that the habitat management plan could reasonably be expected to provide counterbalancing positive benefits. The plan represented currently the sole opportunity to try to improve the status of the species. Sustainable Shetland's legal challenge was upheld by the Lord Ordinary on other procedural grounds which are no longer pursued, but she indicated that if necessary she would have also upheld it under the Birds Directive. The Inner House allowed the minister's appeal. The Supreme Court now unanimously dismisses the appeal. Although the decision letter did not mention the directive in terms, the detailed consideration given to Scottish National Heritage's advice leaves no serious doubt that it was taken into account. The interpretation of Article 2 is not without difficulty, but the minister's duty was simply to consider the effects of this particular proposal, taking account of all material considerations of which the Birds Directive was one. The appellant's suggestion that the development might prejudice the scope for action under the directive, such as the extension of the SPA or other special measures under Article 4.2, was unsupported by the evidence and had not been raised by anyone in representations on this proposal. In any event, the ministers had had proper regard to the conservation status of the whimbrel. They were entitled to give weight to the limited anticipated impact of the proposal, combined with the prospect of the habitat management plan improving their status. Finally, although the directive raises issues on which there may arise a need for a reference to the CJEU in another case, that is the European Court, that is not necessary to determine this appeal.
Court is now adjourned.